Life insurance and annuities usually protected under all 50 states. There's some form of protection. In Virginia, they're absolutely protected. So life insurance policies and proceeds are protected from claims of creditors. Put it into an irrevocable life insurance trust, even more protected. TBE, what's TBE?
Tenants by the entirety.
Thank you, Miriam. Tenants by the entirety. What does that mean? Anyone?
It means each of you owns the right to the entire asset.
Each of who?
Spouses.
Spouses only. It only applies to husbands and wives. You can't have a tenant by the entirety ownership without being married. We talked about this in one of the earlier sessions. What about same-sex couples? Do they qualify for T by E protection? Depends on the state. In Maryland they do, in DC they do, and they have T by E in Maryland and DC. But in Virginia, even though the Attorney General is trying to get legislation passed that would enable that, currently it's ambiguous. There is no such protection. They're not considered married under Virginia law, even if they were married under DC law. For tax purposes, they are considered married. The U.S. Supreme Court ruled on that, and the IRS has followed up on that as well. So for all income tax, estate tax, gift tax purposes, same-sex couples are deemed to be married for all of the tax filings, whether it's Virginia or federal. The T by E property is important, and it's an important way of protecting assets. In Virginia and Maryland, we've taken it one step further. If you're a husband and a wife, and you own an asset as T by E, and then you take it and put it into either a joint revocable trust or separate revocable trusts owned 50-50 and label it as T by E, you still retain that T by E protection. Well, what does that mean? So if husband goes to the bar and punches somebody out and breaks his jaw and gets a $10 million judgment against him, they can't get at the house because wife was not part of the claim. Now this raises another issue for all of you in this room who manage assets. And I'm going to be very specific in my statement to you on this. Joint tenancy with rights of survivorship is not T by E. JTWROS on the account is not T by E. So there is no protection if it's JTWROS. So what do? Convert a JT account into a T by E account if the client wants to do that. And then you can put it into the trusts. It's a two-step process. You shouldn't go from joint tenancy right into the two trusts. It's better to do the T by E step and then put it into the two trusts. That's Virginia and Maryland. DC doesn't have that yet. So you can't have two trusts owning a property as T by E. Now, you're thinking, I've never heard this before. Or Wells Fargo doesn't do that. Or PNC doesn't do that. Or UBS doesn't do that. Or they may. You haven't investigated it. You take it up to the general counsel's office in your firm, you're going to find out that you can do this. It's just that the typical compliance people who are running the compliance operations don't know about it. So they have to be educated. We've been educating a lot of people lately about this. It's asset protection. It's not tax planning. It's asset protection. Some wages are protected, and then they can garnish the balance. Creditors can get a garnishment, and therefore it's a form of executing on a judgment. But they will let you live, but it's not a lot. 529 plans are creditor protected. Question?
On the wages and accounts, is there like an average amount?
It's by table and it's by state and by jurisdiction. So no, there's no set average. What you have to do is it's basically by code, and you can look it up. You can actually Google that garnishment in Fairfax County, Virginia, and it'll reveal the information. You just want to make sure you get up-to-date information because Google often takes you to older information. 529 plans are protected. They're asset protected, even though you have the right to change the beneficiary and the account holder. That's really unique, and it's a very powerful tool. It's a good tax planning tool, and it's also a good creditor protection tool. Disability insurance, like life insurance, is usually protected. It can't garnish or make a claim against your disability insurance. And Social Security is the same way, but it's not that much. So if we're talking about a lot of assets and a big potential claim, we want to really think about how we protect these assets. So insurance is the first line of defense. Of course, there's traditional property and casualty or property and liability insurance, and it comes in lots of flavors. Automobile, homeowners, renters insurance, business liability, errors and omissions, EPLI, employee practices liability insurance, workers' comp, D&O. What about umbrella insurance? Will it cover my punching out the guy in the bar? No. It does not cover intentional acts. It does not typically cover contract liability. Let's see, there's one other common misconception on umbrella insurance, and I have it here. And it's really important because you always think, well, I'll just get umbrella insurance. It'll take care of everything for me. It doesn't cover any of your business or professional liabilities. And it doesn't cover non-traditional vehicles. So it may cover boats, typically, but it doesn't cover jet skis. Did you know that? I didn't know that. I was looking it up in preparing for this. And it doesn't cover airboats, but it covers boats. So non-traditional vehicles are not covered, but it does cover excess liability for boats and automobiles.
So ATV coverage isn't there either?
Correct.
Wow.
Correct. You want to check just check the exclusions, check the exemptions. Always check what it covers, what it doesn't before you sign up. And it's not that expensive to get coverage all the way up to $10 million. Anything over 10 million starts becoming cost prohibitive. But up to 10 million, it's fairly affordable. And I think part of the reason is it doesn't cover everything. So the business and professional liability, that's an important one. And the contract liability that it doesn't cover is really important. And of course, getting health coverage, long-term care, and life insurance is important in any asset protection plan. So life insurance is key. So those of you that manage liquid assets and think, well, I don't want my clients to take their liquid assets and put it into a life insurance policy, you're short-sighted for your clients, because life insurance is absolutely critical to an overall holistic plan for your clients. Question?
Back to umbrella coverage, is there a rule of thumb that you have for how much coverage a client should have based on their net worth?
Yeah, I mean, based on my reading, my rule of thumb is what the insurance companies recommend generally, and that is, if you've got $300,000 of assets, you should get umbrella insurance because your automobile policy, your homeowner's policy may not be sufficient to cover you. How much do you get? Well, you start with $1 million, and you can ramp it up in $1 million increments. You hit $5 million, and then the rates are still extremely low. You'll see when you investigate, it's very, very reasonable to get $5 million of umbrella coverage. Then the question is, well, when do I really need $10 million? Again, if you've got a potential for a claim because of the insufficiency of your basic coverage, your automobile coverage has got a high deductible, and your homeowner's insurance has a high deductible and tons of exclusions, the umbrella insurance may fill in the gaps for you on that. But it may not cover everything. And so having renter's insurance, if you're a business owner, having errors and omissions insurance, if you're a professional, having malpractice insurance, and having a sufficient amount to cover potential claims is absolutely critical and smart. It's good business practice. Any other questions on asset protection plan? So business protection, business entities. What entities give us no protection whatsoever? Thank you. Sole proprietor. What else? There's one other one. General partners. So if you're in a partnership with your business partner and you haven't documented the partnership and it's not a limited liability company or a limited partnership or a limited liability partnership or a limited liability limited partnership, it's all kinds of structures, you have no protection. Even if you put it into writing, it's a general partnership by law, de facto, automatically, unless you've registered it in one of the jurisdictions in a formal manner. A single member LLC. I've got a consulting practice. I'm doing government contracting. Everybody told me to set up my single member LLC and I'll be okay. I'll never have liability. General rule of thumb is you should be okay unless you go bankrupt. If you go bankrupt, Florida, Ohio, and one other state, I can't remember off the top of my head, there have been cases that have pierced through the single member LLC. So just you owning your single member LLC or having your revocable trust own your LLC may not be enough protection for you in an asset protection case. So what do? You just add a member to the LLC.
But doesn't an LLC, a single member or otherwise, or a single member still doesn't protect you against malpractice and E&O, right?
Okay, so the question is, does an LLC, professional LLC, PLLC, PC protect you from malpractice as a professional licensed individual? The answer is no. So in a law firm, this law firm is a PC, a professional corporation. In the old days, lawyers used to set up their own PCs and then own a piece of the company, and doctors would do that too. And that was mainly for retirement planning purposes back in the 1980s. There were benefits to doing that. It's no longer beneficial to do that. Maybe you thought, well, maybe it gives me extra limited liability protection. The answer is no. If you commit a tort, malpractice, negligence, the creditor with the claim can pierce through the PC and go after you individually. That's in all 50 states. So as a CPA, as a lawyer, as a doctor, PC protects you from the torts of your partners. Okay? So it is important. And if you do have partners who are also engaged in the practice of law or accounting or medicine, it will give protection to you from their acts. What about somebody who works for you, who is your agent? No, you're not protected if it's your agent doing your work. What if it's an agent, an employee, working for one of the partners? You're protected from that.
What if it's a consultant and not a doctor, lawyer, architect, CPA?
So a consultant who is not licensed and subject to professional licensing guidelines and scrutiny, and who's not basically taking advantage of the limited liability form as a professional, will not be held to the same standard. So you could achieve limited liability protection. But again, these single member LLCs are being attacked because partnerships have to have 2 or more people. So you can have a limited partnership and have 2 or more people that participate in the partnership and have limited liability, at least for the limited partners. In an LLC, the courts are finding, well, if you've got 2 or more members, you should be able to have protection as long as you are doing 2 things: following the formalities, following the law, following the formalities, following whatever your operating agreement says, and number 2, not being thinly capitalized. So if you have $1 in the bank account of the LLC at all times, that's not really sufficient capitalization to protect you from liability. So what do you need to do? You need to have some level of assets, your computers, a car, bank accounts in the LLC, in the LLP, in the corporation, to provide you with something more than thin capitalization. It's a facts and circumstances test. there is no rule of thumb as to what thin capitalization means. It depends on the situation. But they look at it in regards to you. So if you have $1 billion of assets and you have a corporation like Donald Trump with $5,000 of assets in it, and it goes bankrupt, will he be protected? Well, it depends on how good his lawyers are. So, can they pierce through the corporation and go after the individual and get a claim against the individual? That's the issue.